state documents. When a sympathetic officer or two did give them access to some documents, they found serious anomalies. Entries and signatures were being faked to draw exaggerated wages, most of which were pocketed by officials. The MKSS also discovered some Panchayati Raj documents in which exaggerated bills for rural projects had been submitted. Now, this disclosed information was placed in public domain through live village, via village-based public hearings. That was a very inspiring moment when these Jansunwais were held in villages. And establishment and the people lined up on two sides of the disclosure demand. And then it became clear that the information would require a strong legal backing. And there the demand for an enactment started. Now the initial slogans were, fascinating. Even today I find that how this movement was developed, and their slogans particularly. See, हमारा पैसा हमारा हिसाब, our money, our accounts. हम जिएंगे, हम जानेंगे, हम जिएंगे. We will know, we will live. So that's the really, that's a great, a truth lies in that हम जानेंगे, हम जिएंगे. Therefore, the right to information is very closely connected with right to life under Article 21. This in a simple slogan. This idea was expressed. Now, ultimately, this struggle for poor workers demanding access to their wage records had established a clear link between access to information and one's livelihood. So, I will come to the Supreme Court decisions. There are two judgments which I would like, rather three judgments which I would like to refer to. The first is State of Uttar Pradesh versus Rajnara, and this judgment was delivered in 1975, and Justice Matthew, he spoke of the right to know as a concept derived from the right to free speech and expression. And I may quote his observations. He said, in a government of responsibility like ours, where all the agency of the public must be responsible for this conduct, they can be but few secrets. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. The concept of this freedom of information was further discussed by Bhagwati J in S.P. Gupta's case, and he said, no democratic government can survive without accountability, and the basic postulate of accountability is that the people should have information about the functioning of the government. It is only when people knew how government is functioning that they can fulfill the role which democracy assigns to them and make democracy a really effective participatory democracy. Now then came the election case where the Supreme Court said that the candidate should disclose their assets and their information about the criminal cases filed against them. And there the court said one-sided information, disinformation, misinformation and non-information all equally create uninformed citizens, which makes democracy a farce when media of information is monopolized either by a partisan central authority or by private individuals or oligarchy organizations. This is particularly so in a country like ours, where 65% of the population is illiterate. Then came the Right to Information Act, but just see how it began. Initially some states started responding to it. Between 1997 and 2004, 9 states passed right to information laws, but most of these laws were mere lip service paid to the right to information. And Parliament also enacted Right to Freedom of Information Act 2002. There was a tremendous people's opposition to this particular law, which was passed by both the houses of Parliament, was not brought in force, and finally the Right to Information Act 2005 was enacted by the Parliament. Now Professor S.P. Sathe, he said that the right to information is not necessarily embedded in Article 19(1)(a), that is free speech and expression. I may require information, but not to speak about it. I may require information for some other thing, or to know my rights, to get my wages, etc., like the workers. So therefore, it's not necessarily confined to Article 19(1)(a), but it is also embedded in Article 14, like the equality. I mean, just remember the workers' demand. So it is Article 14 also, and right to life and personal liberty, that is Article 21, because right to life includes, I mean, it's not a mere animal existence, but it's a right to life, is a right to live in a decent, live a decent life. So this formulation was accepted by the Delhi High Court in Subhash Chandra Agarwal's case. Now this very the surest way to evaluate the 2005 Act is to count the feathers it ruffled, see the reactions of the various authorities. Soon after it came into being, the Department of Personnel and Training, the nodal agency of the Act's implementation, declared on its website that file notings were not liable to be disclosed under the Act. File notings detail the chronology of decision-making process, the persons who had access to a file and the rationale behind a decision. As such, access to them is crucial in order to determine whether a decision was taken by the right authorities following the correct procedure and on relevant considerations. After clear rulings from the CIC that the department's information was wrong, the Union Cabinet in 2006 cleared an amendment to the Act. Had the amendment been passed by Parliament, it would have excluded access to file notings and other aspects of the decision-making process. This stringent public criticism and protests led to the dropping of the amendment. Now, even former President APJ Abdul Kalam expressed misgivings about the inclusion of the Presidential Secretariat in the purview of the Act. Disclosure of correspondence between the then President and Prime Minister in the aftermath of program in Gujarat in 2002 was stalled on the basis of the claim that it was constitutionally privileged communication. The Information Commission's order to disclose the correspondence had been stayed by the Delhi High Court. The matter has not been decided, it's pending for more than 5 or 6 years. The Army also sought blanket exemption from the scope of the Act. The problem with these demands is that the Section 8 of the Act already has a list of the exemptions. And what these authorities were demanding was blanket exemptions for all information held by them, sensitive or otherwise. Let me